Did you know that you can be stopped and arrested for a DUI even if you have significantly less than 0.08 blood alcohol in your system?
Did you know that you could be charged with DUI even if you only consumed legal prescription drugs?
Did you know that even if you consume a small amount of alcohol combined with a small amount of either legal or illegal medication or narcotic, you can be charged, prosecuted, and convicted of a DUI?
Did you know that lying or minimizing your drinking to an officer could actually hurt your criminal case?
Hello, my name is William Pernik. I'm a criminal defense attorney and the founder of the Pernik Law Firm. And I'm joined today by Ms. Sarah Schumacher, who's one of the senior attorneys in our firm. Sarah and I have done literally thousands of DUI cases throughout our careers, both as public defenders and private lawyers. And we're now sharing this video with you in order to help you understand the 5 basic components of every single DUI case and how to approach a situation where you're stopped for a DUI, questioned by a police officer, and really scared of what's going to happen next. How do you react in that situation? What do you do? How do you avoid giving the wrong answers? How do you comply with your legal responsibilities? For answer to all of those questions, please watch the rest of this video. Sarah, many people feel that they can only be charged with a DUI if the government can prove that they were 0.08 or more blood alcohol content. Is that accurate?
Well, that's one way they can try to convict you of a DUI. The other way is by proving that 1, you were driving a vehicle, and 2, at the time of driving, you were impaired by drugs or alcohol to the point where you were no longer able to drive the vehicle with the care and caution of a sober driver.
You can also be charged with a DUI even if the government never saw you drive. Sarah, in your experience, have you ever had a case where a person is found intoxicated behind the wheel of a car with the engine running? No evidence the person actually drove the vehicle, no traffic stop by a police, and you still got a client in court facing a DUI charge?
Yes, in that situation, even though no one saw them actually moving the vehicle, the government would try to prove that they were driving by circumstantial evidence. They would look at the fact that the vehicle was running, the keys were in the vehicle, the person was sitting in the driver's seat, it was registered to that individual, and that person appeared to be intoxicated.
In our many years of experience, we identified 5 basic components to virtually every single DUI case. And to help you educate yourself and be ready for that fateful encounter with a police officer on suspicion of drunk driving or impaired driving, we are going to break it down, demystify it for you, and complete this video with a very helpful list of tips and tricks that we have picked up on and developed over the years in order to help you stay out of trouble. One of the first elements to every single DUI case that we have encountered in our career is the driving pattern or a reason for a stop. A police officer on the side of the road or a police officer driving will observe a driver oftentimes engaging in something that brings them to police officers' attention. It might be because the driver is violating traffic laws, swerving in and out of the lane, driving too slowly or too fast for the posted speed limit, driving in other manner that indicates that there might be something affecting the driver's ability to navigate the road safely, perhaps driving with the lights on during the day or lights off during the night. Things that will alert a police officer will inevitably result in you getting pulled over and potentially getting in trouble. When a police officer pulls you over for a traffic violation, anything that police officer discovers is fair game. If they detect that there is evidence of another crime, such as a DUI, they can pursue and investigate you for it. A typical DUI investigation usually follows the following chronology. It starts with an officer observing a traffic violation or a poor driving pattern. It then follows officers' observations of your demeanor and behavior during the traffic stop. An officer will then determine whether or not you appear to be intoxicated using something called objective signs of intoxication, such as slurred speech, red and watery eyes, unsteady gait, or odor of alcohol. Each and every one of these things is highly problematic, and in the many DUI cases that we have handled, we have found evidence of many sober people who have been exhibiting symptoms of intoxication when in fact they have not been intoxicated at all.
They're going to look at your demeanor and how you follow instructions. Cues they're going to be looking for as soon as you roll down your window and start talking to them is the odor of alcohol or the odor of marijuana. They're going to look at your pupil size, whether they appear to be dilated or constricted if they believe you might be under the influence of drugs. They're going to see if your words sound slurred.
If they get you out of the car, they will take a look and see whether or not you appear to be steady on your feet. Those four things, those cluster of symptoms, are something called objective symptoms of intoxication, and they're used in virtually every single DUI investigation in order to justify the next steps.
The officer is also going to be looking at whether or not you're able to comply with their requests. So, for example, if they ask for proof of license and registration and you're fumbling around in your glove box, they're going to try to argue that that was evidence you were intoxicated. If they ask you to turn on your headlights and you accidentally flip the windshield wipers, they're going to argue that you're intoxicated. Your defense attorney can argue in court that each demand you comply with and each time you're able to accurately follow instructions is actually evidence that you in fact are not intoxicated.
But it's very important to listen carefully to what the officers are trying to ask you and make sure that you respond appropriately, because your failure to do so will be misinterpreted, misconstrued, and misused as evidence of your guilt. It's very important during any traffic stop, especially when you're being investigated for a DUI, to not overshare or over-volunteer information.
When you're stopped by an officer and they suspect you might be driving under the influence of alcohol or drugs, they're going to ask you a series of questions. For example, they're going to ask you whether you've been drinking, what you've been drinking, when your last drink was, when the last time you slept was, whether you're taking any prescription medications. You are not legally required to provide answers to any of those questions.
Even more importantly, if you provide deliberately false answers, in particular, if you minimize the time of your drinking, the amount of how much alcohol you have consumed, you could actually inadvertently, unintentionally, completely destroy or certainly damage your defense.
Often people will think they're going to try to talk their way out of a DUI by minimizing their drinking. They might say they had 2 drinks when they actually had 5.
Sarah, if I, for example, had a really nice Manhattan cocktail, and prior to that, several hours ago, I had maybe 1 or 2 Coronas, what's wrong with me telling the officer, hey officer, I just had 2 beers. I'm not lying about the beers. I mean, after all, I did have the 2 Coronas. I'm just not disclosing the fact that I also happen to have a Manhattan.
Later, when there's a chemical breath or blood test, the DA is going to call an expert to try to testify about how many drinks a person would have had to reach that blood alcohol level. If you minimize or lie about the amount of drinks you had or when you had those drinks, it may hurt your credibility later.
In addition, there is something called rising blood alcohol defense, which occurs in about 5 to 10% of all criminal cases. A rising blood alcohol phenomenon happens when a person consumes a lot of alcohol quite rapidly, so much so that their system does not yet have time to fully absorb and metabolize all of the alcohol consumed. In those circumstances, your blood alcohol levels could actually increase throughout your encounter with a police officer, so that when the officer finally receives a breathalyzer test result or takes you to a hospital 45 minutes to an hour and a half later, the blood alcohol content result might be exaggerated and might be a lot higher than your actual true blood alcohol levels at the time you stopped driving. So don't lie to police officers. Don't minimize your drinking pattern, the amount of alcohol you had consumed, or the time of your last drink. If you don't have anything truthful or positive to say, remember, it is always best to remain silent, hire an attorney later, and trust that your attorney will sort the situation out to help you stay out of trouble.
After an officer orders you out of the vehicle, they're going to ask you to perform what's called field sobriety tests. Just like there are questions about how much you've been drinking, you are not legally required to participate in any of these tests.
In fact, field sobriety tests, even though they appear to be a standard tool in investigating DUI, are actually extremely subjective. Unfortunately, in our experience, almost every single time our clients are asked to perform field sobriety tests, these tests and their performance are not recorded in full view of the camera. That means that we cannot actually see what the officers are asking our clients to do, and all we can hear are the instructions and the responses, and that leaves the officer to fill in the gap with a lot of subjective information, interpretation, and misinterpretation. And oftentimes, police officers might be testing you for things that have no proven scientific relevance to whether or not you can actually safely operate a motor vehicle. We'll give you one example. Sarah, almost everyone knows the horizontal gaze nystagmus test. Could you explain to our viewers what that test actually consists of?
With the horizontal gaze nystagmus test, for example, the officer is going to hold their finger or pen in front of your face. They're going to ask you to follow their finger or their pen just with your eyes. They're going to be looking at how smoothly your eyes track their finger, and when their finger is all the way to one side, they're going to be watching your eyes to see if there's something called nystagmus, or involuntary ticking of the eyes. That usually indicates the presence of alcohol. Some people can have nystagmus without the use of alcohol, but that's what the officer is actually looking for, is looking for that involuntary physical reaction.
Sometimes we think that they're testing to see whether or not we can follow the finger. But instead what they're looking for is that involuntary bounce or jerking of your eyeball at maximum deviation. And that jerking of the eyeball has to occur prior to the angle of onset of 45 degrees. Now, Sarah, in your experience doing so many DUI cases, how often do you see police officers carry a protractor?
I've never seen one.
And yet, they're routinely put in their police reports that they observed nystagmus, they observed it prior to 45-degree angle, and that because of that, they believe the person is impaired.
With these field sobriety tests, they have to be performed in a very specific way in order to be indicators of the presence of alcohol or certain levels of impairment. Oftentimes, officers rush through these tests, and if they're not performed in a very specific way, they don't mean anything. We've seen numerous examples of officers rushing through these tests and therefore making these tests invalid.
In fact, in a really well-known study conducted on CHP officers, a group of California Highway Patrol officers that were highly trained, that went through a police academy, and presumably had administered field sobriety tests in the fields hundreds and hundreds of times, if not thousands of times, were asked to perform field sobriety evaluation on volunteers who had consumed various levels of alcohol in order to detect how accurately police officers can recognize these clues. What they found is that the vast majority of trained, qualified, highly experienced California Highway Patrol officers actually ranked the test results incorrectly, got the clues wrong, and frankly, the results were completely scientifically invalid. So, because these tests are inherently subjective, because there is no legal duty for you to perform these tests, it's usually not a good idea for you to concede, accept these tests, and consent to perform them, especially if you have been consuming alcohol, especially if you are alone with a police officer, especially if you're not performing these tests in front of the camera, where we can later take a look at it and grade your performance ourselves using our trained experts in administration of field sobriety tests.
So generally, after an officer asks you to perform field sobriety tests, which you're not required to submit to, they're going to ask you to blow into a device on scene. That's called the preliminary alcohol screening test, or PAS. Like the field sobriety tests, like the questions about what, if anything, you've been consuming, you are not required to take this test.
Wait a minute, Sarah. I thought in the state of California, I was required to submit to a breathalyzer or a blood draw if the police officer was requesting it. Are you telling me now that I don't actually have to blow into a breathalyzer?
It's a little bit confusing because there's two types of breath tests. The first one is called a preliminary alcohol screening test. Generally, the officer will take 2 breath samples if the person agrees to take that test. They're looking for the presence of alcohol and an estimated blood alcohol level. After the preliminary alcohol screening test, the officer will then ask the individual to take either a chemical breath or blood test. It can seem similar to the preliminary alcohol screening, but this is actually the result that matters more. There are more serious consequences to refusing this test.
Now, I know this can seem really confusing to a person who stopped on the side of the road, because you have now been detained for a significant period of time. You've been asked to do roadside exercises in the middle of the night, perhaps wearing uncomfortable shoes or being on unlevel surface, and then all of a sudden the officer asks you to blow into a breathalyzer once, twice, 3 times, 4 times, 5 times. I don't know about you, Sarah, but oftentimes I have clients who really believe that the officers are trying to set them up, that they're just giving them endlessly breathalyzer tests, waiting for them to blow a number that's above the legal limit.
There's a certain number of times a person has to blow into the device within a certain margin that's required. And the officer needs to wait generally 2 minutes in between each test.
They also need to wait for 15 minutes prior to administering a breathalyzer test so that they can be sure that you have not engaged in any kind of behavior that could throw off the results. For example, that you have not been smoking, chewing gum, ingesting anything, using an inhaler, or regurgitated, for example, because all of those things can contaminate the results of a breathalyzer and affect the accuracy of the test.
You may be wondering, how do I know which is the preliminary alcohol screening test that I'm not required to take and which is the evidentiary chemical breath test that I may want to take or may be required to take? Before offering the chemical breath or blood test, the officer is going to read you a statement that's required by the DMV, and it's going to tell you you are required to take either a chemical breath or blood test. If you refuse to take one of these tests, your license will be suspended for the period of a year. When they read you that admonition, you'll know that the next test is going to be the one where if you refuse, there may be more serious consequences.
Wait, Sarah, so what you're telling me is if the officer did not read me the admonition, they're not giving me the real test? That's not the evidentiary test? So I don't have to take it?
If they ask you to take a breath test before reading that admonition, that generally means that's the preliminary alcohol screening test that you are not required to take.
And if I refuse to take that test and they did not read me that admonition, that actually does not count as a valid refusal in the state of California. A lot of our clients don't realize that when we get stopped or investigated for a DUI, there's actually not one, but two different actions that the state will take against a person. One, the district attorney in the county where the arrest has occurred will often file a criminal complaint once they believe they have sufficient evidence to believe that a person is either DUI or is driving with 0.08 or more blood alcohol level or under the combined influence of alcohol or drugs or under the influence of drugs. That is a criminal prosecution that could be either a misdemeanor or a felony if there was an accident resulting in an injury or a person had 3 or more prior convictions within the preceding 10 years. However, in addition to a criminal case, there is also a separate administrative action that takes place in the Department of Motor Vehicles. That action is directed not against you personally, and it will not imperil your liberty. However, it is directed against your privilege to operate a motor vehicle in the state of California. And it is that privilege that will be most affected if you refuse to take a chemical test, either a breathalyzer or a blood test. Because if you refuse a chemical test, your license will be suspended for a year and you will not be able to qualify for a temporary restricted license that could allow you to drive anywhere you want without any limitations with an ignition interlock device or a restricted license that could allow you to drive to and from work. So in many of our cases, we observe that the consequences of refusing a test are oftentimes worse than the consequences of first or second DUI. When we're talking about the DMV, it is very important to remember that a person has only 10 days from the time of their arrest to request a hearing at the Department of Motor Vehicles. Under our law, you have the right to a hearing before the state takes any action against your driving privilege. If you request a hearing with the DMV and you do so within the first 10 days of your arrest, your driving privilege suspension will be stayed. That means it will be frozen, it will not go into effect, and it will not go into effect until after the hearing is held and only if you lose that hearing. In practical terms, what that means for so many of our clients is that it can give you sufficient time to figure out what's going on in your case, to obtain discovery and police reports, to hire a good lawyer, to present the defense at a hearing, and to fight to protect your driving privilege against the DMV hearing officer, who will be both judge and prosecutor, present evidence that he himself will then decide is sufficient to take away your license. We promised you in the beginning of this video that we're going to share with you a short list of tips and tricks that you can use if you're being pulled over, if you're being investigated for a DUI, the things that you can do on the road when you're being questioned so you can come up with the right answers, the right responses, and avoid incriminating yourself and getting yourself in more trouble. Rule number 1. Never give police officer a reason to lawfully pull you over. If police officer is pulling you over lawfully, evidence of any crimes that the officer discovers, including a DUI, is fair game and it will be used against you to get you in trouble. Rule number 2. Never lie or minimize to a police officer the actual amount of alcohol you had consumed. You might be thinking that you're doing yourself a favor, but if you inaccurately report you're drinking, you may actually be damaging your defense in the future and not allowing your attorney to present evidence that your blood alcohol levels at the time of driving may actually have been a lot lower than what they are at the time of the chemical tests. Rule number 3. You do not have the right to have an attorney present when you are being provided an admonition about whether or not to take a chemical test. You are required to submit to a chemical test in the state of California, and oftentimes the consequences of the refusal are a lot worse than the DUI itself. Rule number 4. The police officers will try to get you to agree to participate in field sobriety tests or roadside exercises. Please remember, you're not legally required to take any field sobriety tests, and they cannot use the fact that you refuse to participate in them against you. If the police officer does not have sufficient evidence to believe that you have been impaired, if they have not observed objective signs of intoxication, and you have refused to participate in field sobriety tests, they may not have enough evidence to continue DUI investigation, and they may have to stop what they're doing and let you go home. Rule number 5. Please remember, you are not required to agree to participate in a preliminary alcohol screening test. That's the test that is given without any kind of admonition. If the police are reading you an admonition saying that you are legally required to take an evidentiary test, then you have to comply. But the test that is given without admonition is most likely a preliminary alcohol screening test, which is only used to detect presence or absence of alcohol and is completely voluntary. Remember, blood test is always going to be a lot more accurate than a breathalyzer test. However, it can also detect presence of other substances in your system. So even though the officer is going to give you the admonition that you have the right to choose between breath, blood, or in some cases urine, if you choose to do a blood test, they can also discover in your blood evidence of consuming other substances, such as potentially prescription medication, marijuana, or illegal drugs. Please remember, there are some special circumstances that could significantly increase the impact of a DUI arrest and a possible conviction. This applies if you have been driving and consumed some alcohol while under the age of 21. If you are a commercial driver, if you have a professional license, or if you have prior DUIs. All of those circumstances will significantly increase your exposure to criminal penalties and could result in collateral, adverse, and significant penalties to your professional licensure, to your ability to drive and operate a commercial vehicle, and to your ability to potentially drive in the future for a significant period of time. In this video, we covered the 5 basic components of every DUI case. However, there are some special consequences that could result if a person has been driving while under the influence of alcohol or with 0.08 or more in their system, and they happen to be under the age of 21. That can carry a much more significant period when the government is not going to let you drive legally. There is a 1-year restriction on your driving ability that's going to result from an underage DUI. If you are a commercial driver, a first-time DUI is going to result in suspension of your commercial license for a year. And if you pick up a second DUI and you get convicted of it, you could lose your commercial driving privilege for life. If you have a professional license, a conviction for a DUI could cause significant difficulties for you. The same thing could happen if you're not in this country lawfully, if you are on DACA or protected status. And finally, if you have prior DUI convictions in the past 10 years, all of those things can significantly increase your penalties for the current DUI. So if any of those circumstances apply to you, it is very important that you do not simply show up to court, do not simply plead to a DUI, but instead seek the advice of an experienced DUI defense attorney and make sure you receive the best possible help in order to stay out of trouble, in order to avoid these convictions. Thank you very much for watching this video. Please like, subscribe, and leave us your comments. Thank you.